Court has the right to temporarily remove a firearm where there's danger to themselves or others.
The Supreme Court of the United States just changed the Second Amendment instantly and issued a ruling in the case of New York State Rifle and Pistol Association suggesting expansion of the Second Amendment rights. Will authorities be able to control and ban handguns in courtrooms and classrooms? The conservative 6-member majority of the Supreme Court appeared much more interested in examining the details of an expanded Second Amendment than in debating whether it should be expanded when the court heard oral arguments in November. Anyone who has followed the trajectory of the court's jurisprudence in this area over the past 15 years should not be surprised by this approach to gun control, which is a significant departure from the court's historical approach to the amendment. The Supreme Court that first acknowledged a personal right to carry guns under the Second Amendment in District of Columbia versus Heller in 2008 is far more conservative and pro-gun rights now. Or the Supreme Court accepted that the same safeguards extend to state rules and regulations in McDonald versus Chicago, which was decided 2 years later. Justice Ruth Bader Ginsburg, an opponent of greater gun rights, has subsequently passed away. Justice Amy Coney Barrett has taken her place, and many believe that she has an even more liberal interpretation of the Second Amendment than the late Justice Antonin Scalia, who wrote the Heller decision. After the Heller and McDonald rulings, Justice Clarence Thomas, an ardent defender of gun rights, repeatedly asked his court colleagues to entertain more Second Amendment challenges to existing gun prohibitions. He argued that the Second Amendment's newly established personal right should be used by the Supreme Court to overturn restrictions on the ownership and use of weapons. And Thomas's colleagues consistently failed in such endeavors for many years, up to the nomination of the 3 justices by President Donald Trump. This was then, this is now. We are all currently anticipating the Supreme Court's decision in Bruin, which some court observers predict won't arrive until sometime in late July 2023. The 108-year-old concealed handgun statute in New York is being challenged in the lawsuit. The challengers contend that obtaining a license to carry a pistol in that fashion shouldn't require them to demonstrate a specific necessity. When questioned about it during an oral argument last autumn, the majority of the judges were dubious about New York's justification for the statute. But according to some attorneys and campaigners, the court will continue to make unrelenting efforts to change gun laws across the country after Bruin. The Bruin ruling will come weeks after another shooting spree, this time in Buffalo, New York, where Governor Kathy Hochul and state lawmakers have pledged to broaden gun laws. Will the shooting in Buffalo cause anybody to reconsider the court? No chance. The murder of 19 students and 2 teachers at Robb Elementary School in Uvalde, Texas will also not be forgotten. They were apparently murdered by an 18-year-old who had recently bought his guns in a state with far laxer gun restrictions during the previous 10 years. In Texas, getting a driver's license at age 18 is more difficult than getting a firearm. In response to calls for stronger gun legislation following the shooting of elementary school children in Uvalde, Texas, Republican lawmakers point to the Second Amendment, arguing that the right to self-defense is essential to maintaining liberty and that the government cannot interfere with it. At this year's National Rifle Association conference, held in Houston days after the massacre, Senator Ted Cruz declared, "Rarely has the Second Amendment been more necessary to secure the rights of our fellow citizens." Yet according to historians, the idea that the amendment guarantees people's right to own firearms for self-defense is a relatively modern reading of the Constitution that resulted from a conservative campaign in the 1980s and 1990s. The Second Amendment's official language states that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Historical consensus suggests that for most of American history, the amendment was considered to be in reference to the employment of firearms while serving in the militia. According to Joseph Blocher, a Second Amendment expert at Duke University's Law Department, the Founding Fathers were probably concerned about preventing state militias from becoming disarmed. Siegel claims that this is the first Supreme Court decision to strike down a gun control law in constitutional history, and many conservatives at the time believed the court's reasoning to be overboard. In the ruling, Justice Antonin Scalia claimed that the word militia was only a preface to the meaning and not a core element. According to him, the Second Amendment allows law-abiding people to keep firearms in their homes with the exception of criminals, those with suspected serious mental disorders, sensitive places like schools or courthouses, and people who are in possession of dangerous weapons. The New York State Rifle and Pistol Association claims that the proper cause requirement creates an undue burden on law-abiding citizens, depriving them of their right to self-defense. They said that both inside and outside of the home, the Second Amendment protects a person's right to possess and carry a pistol for self-defense. The group said that the state's strict rules effectively rendered the right to possess and carry a firearm outside the home null and void and undercut the Second Amendment's core principles. In contrast, a ruling in New York's favor may uphold the power of state governments to restrict the possession and carrying of weapons, providing other states the assurance to enact stricter gun control regulations without violating the Second Amendment. Due to the patchwork of various rules around the country, this may make things more challenging for travelers and gun owners. The issue of gun control has long been the focus of contentious debate in the United States. High-profile incidents of gun violence, concerns over public safety, and a desire to strike a balance between individual rights and the requirements of the broader public have all affected the ongoing discussions over the Second Amendment. Social norm shifts and swings in public opinion about gun regulation have an impact on legislative tactics and legal concerns. Implementing rigorous background checks is essential for everyone purchasing firearms. This includes eliminating loopholes that let people buy weapons via unreliable channels like private transactions, gun shows, or internet auctions. Making sure that background checks are required for all purchases, even private ones, aids in preventing banned people from getting weapons. Encouragement and rewards for safe gun storage can help prevent unauthorized access and lessen the chance that the weapon will be used in crimes or accidents. Promoting the use of secure gun safes, lockboxes, and gun locks can help avoid theft, illegal access, and fatal situations involving children or people in crisis. This is especially true when weapons are not being used. It must be done to provide access to mental health treatments and to encourage mental health practitioners to flag clients who might endanger themselves or others. It is possible to stop people with mental health disorders from getting weapons when they represent a threat to themselves or others by encouraging responsible reporting mechanisms and eliminating obstacles that stop mental health experts from sharing pertinent information with the proper authorities. Many people and organizations in favor of gun rights emphasize the significance of the Second Amendment and see any proposed limitations on the use of weapons as violations of people's constitutional rights. They contend that possessing weapons responsibly is a basic right and emphasize the value of having them for hunting, self-defense, and as a deterrent to possible government tyranny. Advocates for gun rights frequently oppose tougher gun control laws, claiming that they might unfairly burden law-abiding residents while doing nothing to deter crime. People who have directly witnessed the devastation caused by gun violence or who have lost loved ones in events involving firearms frequently call for tighter gun control regulations. Their voices frequently draw attention to the human cost of gun violence and demand action to stop future tragedies of this nature. Families of victims and survivors may create advocacy organizations, share their experiences, and strive to alter laws to stop more gun violence. Whereas red flag laws, commonly referred to as extreme risk protection orders, provide law authorities and family members the authority to request that someone with a serious risk to themselves or others have their guns temporarily taken away. By temporarily taking away weapons from people in crisis, these laws offer a legal means of intervening and stopping possible acts of violence while simultaneously guaranteeing due process rights. Investing in community-based violence intervention programs can aid in addressing the underlying issues that lead to gun misuse. Such initiatives concentrate on prevention, resolving conflicts, and helping resources to people at risk of engaging in gun-related violence. These programs can aid in lowering gun violence in high-risk areas by addressing socioeconomic gaps, giving counseling, and promoting peaceful alternatives to violence. Remember to subscribe to our channel to get the latest news from the world of firearms. We can work to make communities safer for everyone by taking a thorough and balanced approach. Click on the video links popping on your screens to watch our other videos in a similar domain.